Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. To help increase your legal knowledge, please hit the subscribe button. For today's case, we have an unusual one because it's an appeal to the United States Supreme Court from the Court of Appeals for the Armed Forces. You don't see that a lot. You don't see the Supreme Court getting involved on military issues. It's pretty rare and pretty notable. But we're here today. We're trying to determine whether some people who did some bad things as it relates to unlawfully and unwelcomingly attacking others in a way that was disquieting. And the government is trying to figure out when it had to bring its complaint. Did it have to bring its complaint within a 5-year statute of limitations, or was there no statute of limitations as it relates to these particular heinous crimes? What is the law as it relates to the statute of limitations? Can we get the servicemen for their unwelcomed, prurient activities? Let's get started with this. We must decide in these cases whether, under the Uniform Code of Military Justice, a prosecution for an unwelcomed assault that was committed during the period of between 1986 and 2006, so this very long period where things happened, did the prosecution have to be commenced within 5 years of the commission of the charged offense? Or could such a prosecution be brought at any time, as is a rule that is present? So did we have to bring this charge against these military officials within 5 years, or could we bring it at any time? The Court of Appeals for the Armed Forces, reversing its prior decision on this question, held the statute of limitations was 5 years and therefore barred conviction as it relates to this unwelcomed assault against 3 military service members. So 3 military members were convicted in a court-martial of performing very bad acts. And the Court of Appeals for the Armed Forces said, well, actually, no, you can't court-martial those people because you had to bring the charge within 5 years. And so the Supreme Court has to decide whether or not they can bring this at any time or whether they have to bring it in with a 5-year time period. The question before us is important, and there are reasonable arguments on both sides, but resolving the question does not require a lengthy analysis. During the period at issue, Article 120A of the Uniform Code of Military Justice provided that these unwelcomed advances could be punished by death. We very much frowned on this in the Uniform Code. And Article 43A, which was amended in 1986, provided that an offense that was punishable by death could be tried and punished at any time without limitation. So if you were suffering the potential of the death penalty, you could bring that charge at any time. The crux of the question before us is the meaning of the phrase punishable by death in the latter provisions. Respondents contend, and the Court of Appeals for the Armed Forces has held, when that phrase means capable of punishment by death when all applicable law is taken into account. Because this court had held in Coker versus Georgia, a 1977 Supreme Court opinion, that the Eighth Amendment forbids a death sentence for the unwelcomed assault against an adult woman, respondents argued that they could not have sentenced the person to death, and therefore the statute of limitations for their crimes, which were committed in 1998, 2000, and 2005 respectively, was the 5-year statute that governed non-capital offenses. So there is a general statute for statute of limitations for federal offenses, and the standard one is 5 years. And in the Uniform Code of Military Justice, it says there's no statute of limitations for anything for which there's a death penalty. However, a 1977 Supreme Court opinion that said, at least in the case of civilians, if there was an adult-on-adult unwelcomed attack, you could not do the death penalty. So the idea will be that even though the regulation says you can be sentenced to death, you actually can't. And because you can't actually be sentenced to death, then the provision that says, well, if you can be sentenced to death, you can bring this any time doesn't apply. So therefore, the statute of limitations is expired and you can't get to these people. Or so the argument goes. On balance, we find the government's interpretation to be the more persuasive one. The meaning of a statement often turns on the context in which it's made, and that is no less true of a statute. And in these cases, context is determinative. The phrase punishable by death appears in a statute of limitations provision for prosecutions under the Uniform Code, and for at least 3 reasons that context weighs in heavily in favor of the government. First, a national referent for a statute of limitations provisions within the Uniform Code is other law in the Uniform Code. So we could look to what other things in the Uniform Code say, because that would make a good basis of comparison. So if we're trying to figure out what this section of the UCMJ looks like, we could look to other sections of the UCMJ, and we can reason by comparison. The UCMJ is, after all, a uniform code, one that has reformed and modernized the old system of military justice from top to bottom. No one would read Article 43's reference to offenses to include those under state law, for example. Correct. So we're only interested in offenses that are defined under federal law. Rather, the Uniform Code establishes that jurisdiction of general court-martial to try persons subject to this chapter for any offense made punishable by this chapter. So the Uniform Code says you can be punished under this code for offenses under this code. Fair enough. If the punishable by death in Article 43A means punishable by death under the penalty provisions of the Uniform Code, the rule regarding the latest possible date for commencing this kind of prosecution is clear. The prosecution may be brought at any time without limitation. By contrast, if punishable by death means punishable by death after all applicable laws taken into account, the deadline for filing these charges would be unclear. The deadline would depend upon the answer to unresolved constitutional questions about which these parties of the case vigorously disagree. Respondents argue that the logic of the decision of Coker applies equally in civilian and military prosecutions, but the government contends that military context dictates a different outcome. Among other things, the government argues that this kind of assault committed by a service member may cause special damage by critically undermining unit cohesion and discipline, and that in some circumstances, the crime may have international implications. So one of the things that is unclear here is whether or not Coker applies to the military, because many things that are in the civilian system don't necessarily apply to the military system, as our military brethren, I'm sure, are more than well aware. So in 1977, the U.S. Supreme Court said, hey, when it comes to civilians, you can't execute someone for this kind of crime. And then it's an open question. Well, can we do it in the military or not? And we don't know the answer to that question. And I don't think the Supreme Court really wants to find out, to be quite honest, one way or another. But in any case, they still have to argue it. They have to argue the logic of the civilian one applies in the military one. And the military says, well, no, maybe it's different for not the least of reasons that, some of these offenses, when they're committed, might actually be war crimes. And, we might want to have jurisdiction for that reason because we want to be able to get at, the war crimes. So maybe this punishment is appropriate in a military context, even if inappropriate in a civilian context. It's arguable. It's an unanswered question. If you don't commit these assaults when you're a member of the military, you won't have to find out which one is the right answer. Don't commit the assaults would be my recommendation. After Coker was decided in 1977, Congress changed the maximum penalty for rape in the civilian cases from death to life imprisonment, but it made no such change in the UCMJ. So after Coker, Congress changed the law for civilians, but did not change it in the Uniform Code. If Article 43A meant what respondents claim and what the Court of Appeals for Armed Forces has held, Congress would have to adopt a statute of limitations provisions without knowing with certainty what it would mean. Indeed, Congress would have to adopt a statute of limitations provision, the meaning of which would not be settled until this court had decided the disputed question of Coker's applicability to the military, which we're definitely not deciding today. Please don't ever ask us. And there was no reason to think at the time of Article 43A's amendment in 1986, this court will resolve that question anytime soon. We have never considered a direct Eighth Amendment challenge to the sentence of death for this assault under the Uniform Code. Please don't ask. And it was predictable that we would not reach the statute of limitations questions until cases like those now come before us before review. That is, until we had occasion to consider charges in which the defense were convicted after being charged more than 5 years after the commission of offense. This is what happens when you ask us questions. We have to answer them. Why do you ask us questions? Please don't ever ask us questions. If you don't ask us questions, we don't have to answer them. But now we have to answer at least one of them. Do you have to bring this within 5 years, or is more than 5 years okay? Finally, if punishable by death under the UCMJ means punishable by death when all the applicable laws take into account, the statute of limitations would also turn on whether, as respondents now maintain, Article 55 of the UCMJ independently prohibits a death penalty for rape. So they have an argument that there's another section of the Uniform Code. So one section says you can give the death penalty for rape, and another section says you can't give it for cruel and unusual punishment. This argument wouldn't work, but, when you're desperate, you try anything. But, yeah. It's the exact same, well, it's not quite the exact same, but it's close enough for our purposes. It's almost the exact same thing as saying that the Eighth Amendment, which prohibits cruel and unusual punishment, bans the death penalty. But that can't possibly be true, because the Fifth Amendment says that life, liberty, or property can't be taken without due process, which implies life can be taken with due process, which implies that death penalty is proper. So you can't possibly read the Eighth Amendment as saying there's no death penalty when the Fifth Amendment seems to exactly encourage it. This was Scalia's point. And so it's the exact same problem now. You can't read Article 55 as saying, hey, no cruel and unusual punishment, as not allowing for the death penalty. That doesn't make sense in context. Viewing Article 43A of the Uniform Code in context, we are convinced that punishable by death is a term of art that's defined by provisions of the Uniform Code, specifying the punishments for offenses it outlaws. And under this interpretation, respondents' prosecutions were timely because there was no time limit. The judgment is reversed and cases are remanded for further proceedings consistent with this. So that brings us to the end of the discussion of United States v. Briggs, a unanimous United States Supreme Court opinion, which interprets the Uniform Code of Military Justice to allow for the prosecution of 3 members of the military who had engaged in fairly reprehensible and disquieting acts. There is a normal statute of limitation that applies to some crimes, of many crimes, in fact, most crimes, in fact, of 5 years. However, any crime punishable by death has no statute of limitations. And they say, well, hey, they outlawed death penalty for this kind of crime in the civilian sector, so therefore it doesn't apply in the military. The Supreme Court says, first of all, we never said that. So we don't know if it applies in the military sector. Please don't ever ask. Second of all, it doesn't matter because what we're looking to is what they wrote. And obviously in context, they were referring to this kind of crime. So whether or not you can punish for death or not, it's in the class of things that were defined that way. And that's good enough because we're looking to original intent. So, these 3 service members can have their convictions maintained. And they can go to Leavenworth and have fun there. And at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.